Hello, and welcome to the next instalment of our Pick and Mix series today. Now, if I were to ask you, who would you like to talk to you about proprietary estoppel? No doubt you would say that you would want someone whose strengths are their attention to detail and being a quality advocate. Well, that's what the Legal 500 says about Nathan. So here he is. Now, if you have any questions for Nathan, then please put them in the question and answer section or in the chat box at the bottom, and he'll be able to deal with them at the end. So over to you, Nathan.
Hi. Yeah, thanks very much, Jarrett. That's a good introduction to live up to. Now, you might think that a talk about proprietary estoppel would involve me talking about cases from hundreds of years ago, or at least you might be surprised to find out about cases from the last decade or so. But actually, it's a really interesting area with lots of recent developments. And I think over the last few years, there have been quite a lot of decisions at Court of Appeal level. And there's very likely, and in fact, there's going to be a Supreme Court decision very shortly, which I'm going to talk about. So despite its age, it's a pretty vibrant area of development in the law. So what I'm going to talk about is essentially in two parts. The first part is about a decision of the Court of Appeal called Guest and Guest, which is a case in a line of Court of Appeal authorities that deal with the proper approach to granting relief in proprietary estoppel cases. It's particularly relevant, and this is part of the reason I'm going to talk about it, because it's been the subject of an appeal to the Supreme Court. There was a hearing that took place on the 2nd of December, and judgment is likely in the next few months. And I think it's likely to be a very significant decision in the area to be aware of. And then the second part of the talk, I'm going to talk about the interaction between Section 2 of the Law of Property Act and proprietary estoppel, and a recent decision of Mr. Justice Snowden on that point. There are, of course, many other decisions that have been published over the last year that deal with proprietary estoppel, but I think these two probably, rather than being mainly dependent on their facts, actually shed light on some principles that underlie the doctrine and the way it's working. So turning then to that first case, Guest and Guest, the facts. Well, like many of these cases, Guest and Guest was a case that involved a family farm. It had been farmed by members of the Guest family for about 3 generations, and the claim was brought by the son, Andrew Guest, against his parents, David and Josephine. And just by way of further brief background, in 1981, David and Josephine each made wills designed to ensure that Andrew and his other brother, Ross, would inherit the farm in equal shares. Andrew then left school in 1982 at the age of 16 and worked full-time on the farm until 2015 for about 33 years. And then from 89 onwards, he also lived in a granary cottage with his wife on the farm. But as often happens, relations deteriorated between Andrew and his parents. In 2014, they made new wills, which excluded him from any entitlement other than the right to occupy the cottage, and then offered him a farm business tenancy, which he declined on the grounds of affordability. He left and found work elsewhere, and then in 2017 brought the proceedings based on proprietary estoppel for a beneficial interest in a substantial share of the farm. And then just for good measure, in January 2018, he was fully cut out of his parents' wills. So what happened? Well, I think you can see that a case like this, if the court can identify some sort of clear assurance over time, that's sufficiently clear assurance that there was going to be some inheritance, working for an extended period on a farm is a fairly typical case where some equity will be established. I'm not going to talk too much about that. What I want to talk about is the order that the judge made in this case. It was a 6-day trial, decision in April 2019, and the judge ordered, effectively, in satisfaction of the equity of the rose, that a lump sum payment was to be made to Andrew of 50% of the after-tax market value of the farming business and 40% after-tax of the market value of the farm, subject to a life interest for his parents in the farmhouse. Now, the almost inevitable consequence of that was that the farm would have to be sold. But the eagle-eyed or eared among you may have noticed that the assurance he relied upon, or the assurance that the judge found he relied upon, was that he would inherit on the death of his parents. But the order required significant payments to be made before their death. So there was an appeal to the Court of Appeal, essentially on 3 grounds. The first was that it wasn't appropriate to base relief on the claimant's subjective expectation. Secondly, that the relief granted went beyond what was necessary and should have distinguished between the current equity that existed and any anticipatory equity that should have been dealt with on the death of his parents. And by current equity, it was said that that could have been compensated for by making a payment, not in respect of the whole value of the farm, but representing an enhancement in value due to the work that he'd done, and indeed compensating him for any loss of opportunity by reason of giving up his life opportunities elsewhere. Now, before I talk about what the Court of Appeal did, I'm just going to summarise some of the key principles in this area, in particular from the case of Davis and Davis, which it contains what I think is probably the best summary of the law on proprietary stock, but it really draws together the different threads. There are, of course, 2 House of Lords decisions in this area, Thornway Major, another case involving a farm and wills, and Cobb and Yeoman's Row, a case involving a commercial dispute between businessmen. And I think the main point to take away from those decisions, amongst others, is that this doctrine applies far more readily in informal family or smaller business relationships than it does at sort of arm's length transactions. The claim succeeded in Thornway Major, it didn't in Cobb and Yeoman's Row. But it's not necessary to go back to those authorities nowadays, because Davis and Davis, a Court of Appeal decision from 2016, which also involves a farm, contains 9 points that summarise the law in the judgment of Mr. Justice, Lord Justice Lewison. So I think that's a very useful case. And then I mentioned these 2 other cases, Haverfield and Moore, because they're both cases where there was a similar acceleration of the equity, like there is in Guest. Both cases involved effectively the courts giving a clean break to the parties upon payment of sums. In Haverfield, the Court of Appeal confirmed the judge had been entitled to award about 1.2 million to a claimant who'd spent 30 years working on the family farm on the basis of assurances. And More was another case where the Court of Appeal adopted a clean break solution, but the appeal succeeded in part in that case because the award was too much at the expense of the parents, the owners of the farm, during the remainder of their lives. You note in this case, in the Guest case, the judge did make at least some allowance for them by granting them a life interest in the farmhouse. So these principles then from Davies, I thoroughly recommend, I think, if you have a case that deals with proprietary stock, or just looking over these, because they really tie together from lots of different authorities, including the House of Lords cases, the important principles. That the first 5 really deal with identifying the nature of the equity and what needs to be established for proprietary estoppel. And then the second 4 principles deal more, I think, with the idea of what remedy should be awarded when there is an equity So very briefly going through these. First of all, it's a retrospective exercise, looking backwards from the moment when the promise falls due to be performed, and whether in the circumstances that have happened, it's unconscionable not for the promise to be kept. What that really means is it's a hugely expensive factual investigation that looks at all the circumstances and what was said and done over a large period of time in most cases. And secondly, you've got the sort of three well-known ingredients: assurance, sufficiently clear assurance, reasonable reliance, and sufficient or substantial detriment. But of course, these aren't watertight compartments. And what's meant by that is that the quality of the assurances can influence the issue of reliance, and reliance and detriment are often intertwined. Perhaps the best example of that is actually Thornham and Major, where it's quite hard to identify the particular assurance that had been given with sufficient clarity, but the nature of the reliance was so extensive that the court had little difficulty in finding that there must have been a mutual understanding. And then you've got points 4 and 5, that the detriment need not be financial, but must be substantial, and there has to be a sufficient causal link between the assurance and the detriment. And in Guest, these requirements were satisfied. There was, as usual, something of a communication issue between father and son. And I say as usual, that's not always the case. But it does tend to be a feature of these types of cases, because if the parties were able to fully communicate what they wanted, then there'd probably be a lot less sort of uncertainty that entered into the relationship. But nonetheless, there was a clear enough indication given in this case, the judge found, about inheritance in respect of the farm. And reliance and detriment also was very clear, because Andrew had been paid a basic wage for a number of years, but had responsibilities that went well beyond the wage that he was being paid. Then we come to the second 4 principles, and this is really what the appeal is all about. What remedy should be awarded when there is an equity that's been established by proprietary estoppel? Well, from many years of authorities, you can, Lord Justice Lewison distilled these principles, that the essence of the doctrine is to do what's necessary to avoid an unconscionable result. Sometimes it said you have to do the minimum necessary to do justice. The 7th principle, the detriment has to be weighed against the countervailing benefits. But it's 8 and 9 that are really key, I think, to understanding the Court of Appeal's decision and the issue that's probably going to, the Supreme Court's probably going to provide some guidance on. And that is that, firstly, proportionality lies at the heart of the doctrine. And what that means is that the court shouldn't abandon the expectations of the parties. But if the expectation based on the assurance that's been given is disproportionate to the detriment, then the court should look to satisfy that equity in a more limited way. And then to point 9, it said, in deciding how to satisfy the equity, the court has to exercise a broad judgmental discretion. But of course, it's not unfettered, has to be exercised on a principled basis, and doesn't involve the well-known portable palm tree. Now, hopefully I've highlighted in amongst all that, but it's still not clear in an individual case applying those principles how the relief is necessarily going to be granted, because a broad discretion is just that. What is the aim of that discretion? Is it to give effect to the claimant's expectation, unless it's disproportionate, or is it to protect a claimant's reliance interest and compensate for detriment? You take the Guest case, for example. Is the aim of proprietary estoppel to award the farm that he expected to receive, or the share in the farm he expected to receive, or is it to compensate him for the loss of opportunity that he gave up and otherwise would have pursued, or the benefits that have accrued to his parents as a result of his additional work? But arguably, the minimum doing the minimum necessary to do justice would suggest the latter, but cases actually seem to be tending more towards the former. And that's in accordance with what has been called Lord Justice Lewison's useful working hypothesis, which is that there's generally a sliding scale by which the clearer the expectation and the greater the detriment and the longer the passage of time during which the expectation is reasonably held, the greater the weight is given to the expectation as a means of addressing the unconscionability, that's to say, giving effect to the expectation as a remedy. And that's exactly the same line that the Court of Appeal took in the Haverfield case when effectively Lord Justice Lewison restated the principle again. And it rests on this idea that where the parties have effectively made a bargain, albeit one that is necessarily informal, if it's passed for proprietary estoppel, then unless there are countervailing factors, it's unconscionable for one or the other side to renege on that. And then, of course, there's the question of why there is a clear break. And the sad fact is that in this case, the judge found that the family simply couldn't continue working together. And that is the same in most cases where you'll see the court order a clean break in a proprietary estoppel claim, because indeed, if the relationship hadn't broken down, it probably wouldn't be in court in the first place. So that's the background. What did the court make of, the Court of Appeal in Guest, make of these grounds of appeal? Well, the first ground, the judge should have looked more, well, shouldn't have looked or placed as much reliance on the claimant's expectation of what he was going to receive, failed. And the suggestion that some sort of objective bystander test, which paid more attention to what the owner must have intended to avoid an unconscionable result, was rejected. And it was rejected essentially because it didn't add anything to the exercise that was being carried out anyway. The essence of the ground of appeal was that it cut through the judge's findings in relation to the components of proprietary estoppel. And the judge was satisfied that there was a clear enough objective assurance that was given. And so talking about an objective bystander didn't really move matters any further forward. What about the suggestion that the court should have considered alternative relief? Remember, splitting up the current equity and the anticipatory equity, and not accelerating what the claimant would have achieved if the understanding had gone through to a will. Well, again, that ground of appeal failed. It failed because the court thought that it didn't give enough weight to the nature of the assurance that had been given, enough weight to the expectation that had been created over a long period of time. And then thirdly, ground 3, should the remedy have been accelerated in some way or structured so that it wasn't accelerated? Well, again, that ground of appeal failed at the Court of Appeal because there was no prospect of the parties continuing to work together. And a clean break solution has been adopted in a number of Court of Appeal decisions, and the court wasn't minded to depart from it and do something more intricate in this case. But that is how matters lie at the moment. As I say, there was a hearing in front of the Supreme Court on the 2nd of December of this year. And the issue essentially is, firstly, the Supreme Court is going to give a judgment on is whether a successful claimant's application in this case of inheritance for family farms, an appropriate starting point when considering a remedy. And secondly, whether the remedy granted, namely the accelerated payment of a lump sum, went beyond what was necessary. Now, I know enough not to try and predict what the outcome of the Supreme Court's likely to decide, but I think it would be surprising on the first point if it departed too far from the statement of principle that Lord Justice Lewison outlined, the rule of thumb that he has suggested and applied. But I think more interesting is this second point about the circumstances in which accelerated lump sum payments are appropriate and when a clean break can be justified. Because standing back from it, I think you can see that what the claimant actually obtained in this case was more than he would have obtained at this point in time if the expectation and understanding had proceeded as everyone expected it to do in him finally inheriting the farm. So this is a really, I think, topical issue. There's going to be a decision on it in the next few months, and it's likely to affect, I would think, cases that come to trial certainly after it, but cases progressing along the way at the moment too. So that was the first point, decision I wanted to flag up. The second is actually quite an interesting decision of Mr. Justice Snowden, Howe and Gossip. And for those that deal with proprietary estoppel, they'd be aware of this long rumbling issue about the extent to which you can rely upon proprietary estoppel in circumstances where Section 2 of the Law Property Miscellaneous Provisions Act applies. Remember, that's the section that says in order to have a contract for the sale of land, you need to have the contract in writing, contain all the terms and signed by parties. There's a specific exemption from that for resulting implied or constructive trusts, but it says nothing about proprietary estoppel. And that has led various judges over the years to speculate that it therefore can't be relied upon when Section 2 would otherwise be engaged. Now, the decision of Mr. Justice Snowden goes some way, I think, to removing the uncertainty about that point. I'll touch on the facts very briefly, but in essence, the Howes owned a farm. They sold part of it to the Gossops. As part of the original sale, the Gossops were to do some work on the farm, for which they were to be paid about £7,000. I think it was improving an access way. That, what it was for isn't important, but there was then a subsequent meeting in 2012 at which they discussed an alternative proposal, which was that in exchange for waiving that at £7,000, the Gossops would acquire 2 further parcels of land, green land and grey land. In effect, it was a contract for the sale of land, but it was never reduced to writing. Following the meeting, the Gossops undertook work on the land, then relations broke down, and the Howes sought possession of the land in the county court. This is a decision actually that came before His Honour Judge Safman, and he was satisfied that he could rely upon the doctrine of proprietary estoppel and granted an irrevocable licence over the green land, not over the grey land, because it turned out that that was too uncertain to identify, but the green land wasn't. He granted a licence, and he was satisfied that even where an agreement did not comply with Section 2, a proprietary estoppel could still arise and the court could still give effect to it. And the fact that the Howes hadn't said anything about the validity of their oral agreement didn't affect the court's ability to use the doctrine. And it's probably also important in this case, actually, that the Gossops had only sought to obtain an agreement in writing after they'd done the work. Had they done it before, there would have been difficulties with reliance, because if they tried to obtain a written agreement and they'd been told they weren't going to get one, then they would have found it much more difficult, I think, to persuade the court, as they did, that they thought the agreement was binding, notwithstanding that it wasn't. So there was an appeal on 3 grounds. The main ground being that this was a contract of sale which failed to be binding because of Section 2. And there was no representation as to the validity or otherwise of the oral agreement by the sellers, the Howes. So it wasn't inequitable, in effect, for them to rely upon the statutory provision and say that this agreement was unenforceable. I mentioned the previous cases in this area and what has been said. It's an interesting read if you have time to go through them. But perhaps I'll just highlight the first one. Lord Scott said in Cobb and Yeoman's Row that his present view at the time of that case in 2008 was that proprietary estoppel couldn't be prayed in aid in order to render enforceable an agreement that the statute had declared void. Lord Neuberger touched on it in Thorne and Major, but was satisfied that Section 2 wasn't really touched upon in that case anyway, because there was no real contractual claim. It was really about what had been promised in a will. And Mr. Justice Snowden observed that obviously the case of Howe and Gossip fell between the two extremes of Cobb being a very commercial arm's length deal and Thorne, an informal family relationship. But nonetheless, it was still a case that involved parties who weren't overly experienced in property transactions. And I think that's an important point because of something that Lady Justice Arden said in the Herbert and Doyle case, which is that if the parties intend to make a formal agreement setting out the terms on which one or more of them is to acquire an interest in the property, or if further terms of that acquisition remain to be agreed, or if they don't expect their agreement to be immediately binding, then she said and held that neither party can rely upon a proprietary estoppel effectively to enforce that agreement because they can't show that they relied upon it reasonably. Although in Dowdy and Matchmove, the Court of Appeal pointed out that it's important not to overstate those, what Lady Justice Arden said. It's as if it was statute. It was simply a way of describing what in fact had happened in Cobb. So what did Mr. Justice Snowden conclude on appeal? Well, he took the view, which I think has been coming through a lot of different case reports over the years now, that there's considerable doubt, in fact, that Section 2 was ever intended to affect the operation of proprietary estoppel at all. He approved, in fact, an extract from Snell's Equity that effectively said that it's a proprietary estoppel, a claim based on proprietary estoppel is quite distinct from a contractual claim. But even if it did, it could only operate to bar relief to the extent that the relief was enforcing an unenforceable contract, which of course the gossips weren't doing in the present case. They were just asking for an empirical license. He confirmed exceptional circumstances aren't needed to rely upon it in these circumstances. But I think putting aside the detail of this case and the fact that the gossips weren't actually looking to enforce the contract is perhaps missed the point of it, because he goes on to say, Mr. Justice Snowden, that if a claimant is seeking relief, and this is at paragraph 66, that amounts to enforcing a non-compliant contract, he needs to point to something else as the basis for an estoppel based on unconscionability. It cannot simply be that the contract is unenforceable and that the other party is seeking to rely upon the statute. And he gave an example of an earlier Court of Appeal decision where a defendant had encouraged and represented to a claimant that an agreement was valid, notwithstanding the fact that it wasn't. So in a straight enforcement case, it seems that Section 2 can, at least where the parties don't expect, well, I believe an agreement to be binding, even though it's not, can be relied upon. But it needs something more than just the fact that it's unconscionable for a party to rely upon the statute. It's not unconscionable for to do that. And this isn't that sort of abstract a point, because it's cropped up, Section 2 point, in at least 3 decisions this year. Another case involving Mr. Justice Snowden, Hellfire Entertainment, a case that had a very interesting procedural history because it was struck out at a case management conference, and there was an appeal against that decision that ultimately failed. as part of the appeal, there was an amendment to the pleadings that by which the claimant sought to rely upon a proprietary estoppel to say that there was an enforceable contract for sale. But in that case, the two individuals involved knew and agreed that there would have to be formal legal agreements before they were banned. And so that claim had no real prospect of following what Lady Justice Arden had said in the Doyle case. The other two cases turned on quite similar points, the Smoke Club Limited and Kirkbride. In both cases, well, in the first case, the parties had only reached an agreement in principle, and they knew it was only an agreement in principle. And in the second, the parties knew they were negotiating subject to contract, so the court found. But I think, as I say, the proprietary estoppel feeds into lots of different property cases. It's not just farms that it involves. It tends to be those cases that go to the higher courts because of the values involved. But proprietary estoppel, I think, is an issue that that crops up in lots of different property transactions, at least those that are away from the sort of true arm's length commercial transactions. And as I say, there's likely to be some quite significant guidance handed down by the Supreme Court very shortly on the right approach to relief. And so it's important to be aware of that, I think, in the coming months. And that's the end of my talk. So thanks very much for listening.
Thanks, Nathan. That was great. It's one of those things that interface between Section 2 and proprietary estoppel comes up all the time. So it's good to see that the law is inching towards a bit of a conclusion on that. That was really useful. Thank you. I've been monitoring the Q&A in the chat boxes, and so far we don't have any questions. So last call for questions for Nathan on the proprietary estoppel. Going once.
Right, I think we've covered everything off.
You've got away with it, Nathan. Right. So thank you very much, everyone, for attending. The next talk is 4 o'clock. Nick Taylor and Ian Cooper talking about possession actions. So thank you very much again, and see you next time. Bye-bye.